When the screen goes dark and the world won't start, you know who to call, yeah. Watching you struggle with that frozen screen. 3 days now and you're losing your mind. I see you typing but nothing's working right. Daniel's got that look in his eyes. From sunrise to the end of the day, you're always fixing what's broken away. Why do you always stay when everyone else would walk away? Why do you always care, Daniel? Why you always there? Coffee's getting cold while you run diagnostics, explaining every step like I'd understand. Your hands move fast across the keyboard magic, making sense of what I can't comprehend. From sunrise to the end of the day, you're always fixing what's broken away. Why do you always stay when everyone else would walk away? Why do you always care, Daniel? Why you always there? Maybe it's not about the broken parts. Maybe it's about the way you see. Every problem has a beating heart. You won't give up on me. Now the screen's alive and everything's running smooth. You pack your tools with that quiet smile. I know tomorrow when something breaks loose, you'll be back here in a little while. That's why you always stay when everyone else walk away. That's why you always care, Daniel. That's why you're always there. And the screen goes dark and the world won't start. I know who to call, yeah.
All right. Welcome. You know, I tried the thing with the new YouTube channel and it didn't work. I created a channel and tried to verify it, and it wouldn't let me verify it. So I waited a couple days. I tried to verify it again with one of my neighbor's cell phones. And it wouldn't let me verify it. It said I made too many attempts. I tried it today. It said that I made too many attempts to try back. I said, you know what? I'm just going to delete it and let the content be on this channel. It's not hurting it being on this channel. And anyway, it's just easier to do it. So I decided that everything is going to stay on this channel. I am not going to create another YouTube channel because YouTube is being a bunch of dumbasses. So today is our landlord tenant docket. We'll start out with a little Judge Simpson. How do you like that? So let's make this bigger.
Okay. There you go.
Alex Henry, on behalf of the defendants.
All right. Okay, folks. Thank you. I think we had a little mix up in time, but I think everybody's here. And I'm almost afraid to ask, where are we?
Yeah.
Go ahead, Mr. Freeman.
I was just going to say that there has been significant progress made. There's been some, I guess I'll say, stumbles along the way, but significant progress is being made, I think, on schedule. The fire doors that were in question did arrive, are being installed. There are some issues with inspections and building permits that need to be ironed out. I don't believe due to any fault of the property manager, but my co-counsel has been very actively involved dealing with the property manager, communicating directly with the property manager, and I think is better prepared, informed, I should say, really, to address the issues that are still remaining. But that being said, we do believe we can meet that schedule that was set previously.
Okay, if there's one AI site builder you need to meet, this is Dope Tech from Wix.
Yes, Your Honor. Ms. Ellis indicated fire doors are ordered. As you know, we submitted the plan to you at the last hearing.
Yes.
There were a number of permits that the city was requiring the property manager to pull. Those have been pulled. My understanding is on May 2nd, there were 13 building permit inspections scheduled. 12 of them were passed on that day. There was one that did not pass due to, I believe, the drywall not being painted at the time. But the
drywall not being painted.
Yes, the drywall. Yes, so the 13th one failed because the drywall was not primed yet. FDIC, the vendor, had a hard time getting the mud to dry with the tenant taking a steamy shower, so it was not able to be painted. They requested to have a photograph of it being primed, sent to the city within maybe, I believe it was like 30 minutes after, and they were told that they could not do that. So they had to reschedule it for a new inspection, which I believe, Stuart, was that new inspection done?
It's the time for this weekend.
Okay, so that new one is scheduled for this week. There was the scope testing that was to be done on areas. They received a proposal from TEK Environmental. The proposal was executed by the ownership, and they're just waiting for scheduling for that from TEK. So that is in the works to be completed.
Okay.
There were 2 items with electrical permits for 2 of the units in 721 Clark. The property manager is hiring LR Rolls Mechanical to pull electrical permits and schedule those inspections. Similarly, with a ceiling fan that was in a unit within 721 Unit 206, LR Rolls is being hired to pull the electrical permits for that as well.
But those electrical, they haven't been pulled as of yet, but you've hired somebody to.
Yeah, so the idea is that the company comes in and pulls the permits during that process. So they're working on hiring LR Rolls to do that. There was also, there's this boiler boiler letter and baseboard covers. There was a request by the city that we provide them with a boiler letter. Basically, that would attest to the fact that boilers are in working condition. The boiler letter had previously been sent to the city on March 17th, April 8th, and April 29th. We received a correspondence from the city on the 29th saying that the letter needed to be signed and dated per building, and that the letter did not have the building addresses on it. And so a new letter was provided to the city, and it was indicated that the signature was not a wet signature on the letter, and that the person doing the inspection is not the license holder. So we're trying to get in contact with the contractor so that they can communicate maybe with the city directly to get them what they need. But it seems like,
So the 3 boiler letters, are those for 3 separate boilers?
yeah, I believe that the company came in and looked at all of the boiler covers, or maybe Mr. Beal could speak better to this. Can you speak about the boiler letters and what that is?
This is one of the last remaining issues that are going to cause a problem on May 20th. The city is requiring a letter from a licensed boiler contractor to say that the boilers are operational. We provided that letter 4 times over the last 45 days, and it still has not been accepted by the city. And so we're asking the city to accept it in its most latest iteration. But one of the problems is that the boiler system is very expansive and complex. It has 24 apartments in each building, and there are radiator covers in each apartment that Jerry, the inspector, says if they're damaged, they need to be replaced. But
Well, I don't need to know what the problem is. What I'm trying to figure out is the letters that were sent. Were those encompassing all of the boilers for these particular units, or what were they?
So there's one boiler per building, and we provided 1 letter per building now.
All right. Okay.
And so as Mr. Beal indicated, this is going to potentially be an issue coming on the 20th. So the position is that they want all of these base board covers that deal with these boilers replaced. And that is going to be approximately, I believe you said about $20,000 a building. And so to the extent that this letter is saying that these boilers are operational, the property manager and the owner are saying that they will replace the boiler covers that are the most damaged, obviously, but to the extent that they're still working properly, it doesn't seem reasonable to require them to replace every single baseboard cover in order to pass this inspection on the 20th.
And to be clear, the city is not requiring us to replace every baseboard cover, but they're not telling us which baseboard covers they actually want replaced. So that's why it could be an issue on the 20th. So the city should either let that go or tell us.
Why don't you sit down?
Thank you.
You don't need to tell them what they need to do. All right. Okay, go ahead.
Also, the city was requesting a letter regarding pest control. It's my understanding that we have that information, and if it hasn't been provided to the city, the instruction is to provide it today. I believe I saw it at the end of last week, so that letter will be provided to the city.
Indicating that somebody's been hired to do it, or that it's been completed.
It would be the contract for the pest control, letting them know when they're coming out, how often, services, things like that. So that'll be provided to the city as well. And then as Mr. Beal, I think, indicated as well with regards to inspections that are happening at the property. Another issue that we've run into recently has been scheduling the inspections and having the city come out to do the inspections. We're requesting inspections for several buildings on certain days, and the communication that they're receiving from the city is that you have this window, we're not calling, we're not going to the office, we're not asking for anybody, somebody be at where they need to be when we arrive. And if we've got 15 buildings scheduled for inspection one day, we don't know where the city is going to come up. So we're dealing with those kind of issues where they're refusing to communicate, and time is of the essence at this point. Everybody at the property is valuable. So having multiple employees camp out for a 4-hour window potentially to see whenever the city arrives, as opposed to a brief phone call, I'm on the way, it's becoming a bit problematic. So we're hoping that permits, to the extent that any additional need to be pulled and inspections need to be done, that this is not going to delay the process. So that's just something we wanted to bring to the court's attention as well, because that was specifically occurred with regard to those 15 that we had scheduled for May 2nd. So.
Can you please just hear me out? No, all work management platforms are the same. They take forever to learn, and in the end.
Outside of that, I think that those were the main issues that we wanted to point out with regards to the plan and the progress. There also has been a request for 2 special inspections to occur this week with regards to drywall that needed to be removed. So just in the process of getting the work done, drywall was removed that, they didn't anticipate being removed. So they're requesting special inspections to occur this week so that we can ensure that we're on track for the timeline. There has been no response to that request as of yet, but that request has been made to the city. And that would be the primary things we would want to flag for the plan. We do have a copy of the most current list of items from the correction order that were ongoing from the city, which we can provide to your clerk via email.
Yeah.
It gives a layout of what's been done and then also kind of the plan for getting those things done by the 20th. I just received those, so I don't have a printed out copy, but if that's something the court would like, we can make sure that
That
email to you all. And that is the ones for 720 and 721. So we can make sure that the court has those.
wonderful. All right.
Yes, John, I had a chance to speak with Mr. Myers about all this, and it does sound like there's some progress being made, but it sounds like because of the fact that they're inspecting the other buildings at the same time, as well as other properties that Beal owns, that they haven't had the chance to get to where they need to be, where they think they're actually going to be on time to make it to the original schedule. I think about half the inspections they've been
What
doing
is
on the
that?
property- About half the inspections they've been doing on the Beal properties or on the Arbor One properties have been for other buildings that aren't these 2 buildings in question. So for that reason, they haven't been able to meet all the requirements that they have to for all the inspections. But I think Mr. Myers should probably speak better about this than I can.
Well, come up, Judge.
Yeah.
Yeah, over the last 3 weeks, we have done about 73 inspections at Arbor One. 38 were on these 2 buildings, so roughly half. 16 were approved, canceled, or not ready, disapproved, so they're failing a little over 10% of all of these inspections. They're scheduling inspections for other properties that Mr. Beal owns and not these buildings, which is taking up our inspectors' time away from being able to inspect these buildings, to where next week we have 5, or this week we have 5 open inspections, 1 on Tuesday, 1 on Thursday, and 3 on Friday. The special inspections that they requested on Friday at the end of the day are for times that we don't have inspectors working or that we don't inspect. Because they asked for 1 on Friday at the end of the day at about 4, I think, and then Monday at the end of the day when we don't have an inspector. So we have 8 permits scheduled for this week to be done. There's about 20 that needs to be done. And so we have done whatever we can to make this happen. As far as the inspection, we give everyone a window. We have been told that we treat people differently, but we give everyone the same 4-hour window for inspections. And then we've also said on several occasions that we're going to always start at 721 Clark, it's the first address. That's not good enough for them, but that's really what we can do. But yeah, it's very concerning that out of
What's not good enough? What do you mean that's not good enough?
So they would like the exact time that we're showing up, when we really don't know when that is, because the inspections happen all throughout the city. But yeah, so this week we have 14 inspections scheduled for Arbor One, but only 8 of them are on this building, these 2 buildings. So it seems like they're prioritizing other buildings over these 2 buildings.
Why do you say that?
Because if these two buildings are the only concern, which we've been told in an email from Mr. Beal that the city's only concern is approving these inspections, they're prioritizing other buildings in the complex
Yeah, but
permits.
what's gonna happen is that if they don't, I don't know if that's a prioritization. It's that this is sort of an ongoing concern.
Mhm.
So if I'm working over here, because that may be my next phase that I'm going to try to get some things done, then I would be trying to do them both at the same time.
But we only have a limited number of inspections we can do in a day. And so by taking them away from these two buildings, we're being pulled from those two buildings.
Okay. Regarding that,
Your Honor, if I may, I find that statement incredibly problematic because if we weren't doing work on other buildings, I mean, property's actively being cited by the city and other buildings as well. So we're splitting time and I don't see that as a problem, but as Mr. Myers indicated, majority of those requests were for these two buildings. So, also, last hearing, Your Honor, you were inquiring with the city with regards to, I guess the third-party contractor that comes in and does certain permanent inspections and things of that nature. Since that hearing, we have spoken with one of their representatives, Jeff Schaefer, individual who does the building permanent inspections typically for Arbor One. And he's indicated to us that he's having to find other work because the city is not keeping him busy enough. And because Jerry Dunham is now doing all of those inspections. And he's a little.
hold on a second. So this is a third-party person to do inspections. That's at least telling you that he could do more, but that he's not being requested to do more.
Correct. He's Jeff Schaefer.
Stop there for a second. What, do you know anything about that? Huh?
No.
Okay, go ahead.
Yeah, our property management team spoke with Jeff Schaefer, who is an employee of Code Enforcement Services, CES, the company that the city contracts to do the building inspections. Jeff indicated that he's not being kept busy enough with the work now and has to reach out to others, get work from other municipalities because Mr. Dunham is now doing the inspections that he previously did. This is, on top of the scheduling, this has been an issue for us as well because working with Jeff, the process was, streamlined. We would do the inspections. He would give us yellow cards, letting us know the inspection results, and we would be able to, continue on from there. We now have Jerry doing those things. We're running into we're not answering the phone. We're not letting you know when we're coming. We're not calling, as well as you're not giving us inspection cards. So we have no verification at a certain point to establish whether or not we passed, which is problematic from a property management perspective with the city coming out. We want to be able to verify when an inspection is passed and when it's not. So at this point, their position has been that they're not required to give them. But up until this point, we have always received them from CES. So just something we wanted to flag with the court as well, because these are things that are.
Well, hold on. Can this guy do more inspections?
So per our contract, and
Whose contract? With who?
the city and CES,
Okay,
we can do 6 inspections a day. We have done more than that over the last 2 weeks, and we have yet to,
with this company?
with both with Jerry and this company, to make sure we get the inspections done.
All right, get on the phone right now, find out how many inspections he can do in a week. Let's do it right now. Because this doesn't make any sense to me. If somebody can do the inspections, then let's get them done.
With Thrivent, your financial journey isn't a solo mission. Your money is a tool to support the people, causes, and community you love. Because sometimes all you need to make a difference is someone to help you make it happen.
Another issue I was hoping to bring to the court's attention.
Sure, go ahead.
So some of the tenants that have been relocated both in and out of court to the township side, they've continued to escrow their rent. And now they're receiving 7-day notices to evict them. One of those people, Miss Natasha Drake, is in court today.
So she's receiving a 7-day notice. With, but they're on the township
On the
side.
township side, but she's been escrowing her rent
Here.
in this case. Yeah.
Okay. And she's escrowing it on her case right here, right? Okay, so just so that you know, and we haven't quite worked it out, Judge Washington is aware who would be handling the township cases. She's aware that the escrow is being paid here. How exactly that financial mechanism is going to work, we're not sure. Is the rental amounts the same? Or, well, that's going to be the part of the issue. The other part of the issue is who's going to be paying for that relocation, which is another issue. So
That's a twofold issue because, of course, we had our hearing with Judge Conkey last week on our preliminary injunction motion presented by the city prosecutor. That has not translated into an order yet for various reasons. However, if she addressed the issue of rent payments, relocation of tenants, she's made clear that tenants who are requesting relocation assistance can speak before her on 3 days' notice.
can do what?
Can appear before her with a motion on nearly 3 days' notice.
Okay.
She did reserve the issue of various things like emergency repairs, health and safety related repairs for a hearing. It was originally scheduled for 6/6 inexplicably. It appears that hearing's been moved to 6/20. Any tenant desiring to be relocated is to receive a 100% refund of all of their escrowed funds and all of their paid rent from 9/17. So that would affect, obviously, the escrow order of this court once her order is entered, and also the escrow.
They're to receive what?
They're to receive a refund of all of their rent paid from 9/17 if they paid rent.
From 9/17.
9/17 of 2024, which was the date of the suspension of the certificates of compliance. And that they would be prohibited from seeking to collect rent while there are no certificates of compliance, because that's explicitly what the ordinance requires. It also prohibits leasing of buildings at the Upper One property on the city side. Also prohibits all rent collections, that I believe I just said. And so she's looking at relocation on a case-by-case basis and addressing the
Has the
refund of escrows on a case-by-case basis.
Well, I'll wait to see her order on that. Then deal with
There's a
it.
lot going on, obviously. I'm not sure what you were aware of.
Mr. Henry, so what's going to end up happening is, even if it's going to be a bit problematic returning escrows, because the escrows may need to be paid, or at least these people could end up being relocated to the township side. And now you've got basically 3 courts with their hands in it, trying to figure out what to do. So I think between the three of us, we'll be able to figure it out.
You said Mr. Drake was,
Ms. Drake is one. I believe it was also Mr. Blankenship. Then there was some that were not in court, like Alina Jordan, Lawrence Grove, and Weena Harris Freeman.
and these individuals have all been relocated to the township side?
They were all originally on the city side, relocated to the township side.
Okay. Township side has COCs. So
Correct.
why are they still escrowing their rent when they are in a?
Because they wouldn't be on that side, but for what's happening on the city side.
I think another issue is they were relocated, given new leases, so they don't know if they have an increase in rent, a decrease, or if it's the same as previously. Some of them have leases that are ongoing, some the lease expired. So they've just been escrowing the same amount that they would pay either to the court or to the city.
And I mean, that's,
I don't need, Mr. Beal, I don't need your comments. Go ahead. What were you gonna say?
so the court has ordered that even if they're on the township side with COCs.
I've ordered them to comply with my escrow order.
Okay.
And where they can either do it to the court or to the city. Because the question really is going to be, if they've been relocated, do they intend on coming back, or should they be paying for where they are? And I guess maybe the way to look at it is, it's one thing if they're in a new apartment, and one can look at that in one way. Or you look at it from the standpoint that if they were placed in a hotel, then would they be paying the hotel bill? No. Right? So is this temporary? And I think and Mr. Henry, you can correct me if I'm wrong, but the real question is there relocation to the township site a temporary solution, or is that a permanent solution that at some point that's where that person's going to be?
Right, and I think that would kind of speak to the answer to his question, is to speaking with all these individuals to see if they intend to stay in the township side, or if their intent is to, again, be relocated back to their unit. If they intend to stay, then I think that conversations to be had about whether or not they should be paying rent.
Well, and whether or not they have a lease.
Right, and then,
I mean,
further.
I would agree with you in that respect, but remember how this all started. It all started because the units on the city side were not in compliance, so these people had to be relocated. The people get relocated, and some of them are put in hotels, some of them are put in other units, with no clarification as to the permanency of any of that. So.
If I may, Your Honor, it seems if somebody's been relocated to the township side in a certified unit, they are certified, that and they wish to stay there, they like the accommodations, and are willing and able to sign a lease or a lease extension, that rent should resume. It's there's no health, safety, or certification issues that would include the landlord from requesting rent for a certified unit that the person intends to reside in.
If they have a lease.
Yes.
But I don't know if any of these people have leases.
That's my understanding, that they don't have leases. Ms. Drake, is that correct, that you don't have a new lease?
I'm sorry.
That's correct.
You don't have a new lease. Yeah. So, I mean, ultimately, the real issue is, are they intending on staying there? Have they moved? Or have they, I guess, for lack of a better term, have they relocated or have they moved?
Right.
That's really going to be the issue, as far as I'm concerned. But
And we can, obviously, I can communicate with legal services about having those conversations to see if some of these issues could be resolved. Because I think that, this turns on a few of those questions that I don't think anybody has a clear answer to at this moment. So what the intent of the tenants would be.
do we get an answer regarding the inspection?
So not quite, but I have an answer that I think will satisfy. We have not denied any inspection at this point. We are running out of time for the 20th, but we have made it work. We might not be able to make it work with the timelines that they want, like end of day Friday and Monday when we don't have any inspectors. But we have yet to deny one inspection. And so
I don't know that that's what I asked.
and I have not been back to our company that does it. And so
Pardon?
I have a call in and a message to call me back because I'm in court, but I have not gotten a call back from CES.
Wouldn't that really dictate in certain respect whether or not the 20th is going to be able to happen?
And the boots on the ground are telling our boots on the ground the 20th isn't going to be happening.
What?
So even our boots on the ground are hearing from their people that they're not likely to make the 20th. They're only pulling permits on certain things. Even last week, as you heard from them, there's certain permits that haven't even pulled. They haven't hired the person to pull them, and that's been 2 weeks ago that they agreed to pull those. So we have issues. The city's not the problem here, ultimately, Judge.
Well, I think everybody's a problem because what I'm hearing is I don't think people are communicating. I think people are getting in certain ways for whatever the reasons are. And that's fine if everybody wants to act that way. I mean, I certainly will let Judge Conkey know what I am seeing on my end regarding that. But, if I mean, just by way of example, if one side is hearing that somebody can do more inspections, but for whatever reason, those inspections can't be done, that doesn't make any sense to me. I mean, it's like everybody's talking two different scenarios here, which makes no sense to me.
Meeting we had here a couple of weeks ago, they asked us to attend, and one of the items that came out of that was insistence on our part and agreement with theirs. There would be a single point of contact. So we didn't have this, he said, she said folklore, from whoever was being spoken to. We identified who we wanted to have as our single point of contact. And it was our understanding that they would do the same. And, when there's a disconnect like that, again, that we try to address.
How many inspections on 720 and 721 are there this week? Yeah.
8.
That's all that's been requested.
Yes.
Is that correct, Council?
Oh, that's accurate.
Yes. 8 have been requested. 8.
Join me for the future of health. 2 hours every day under 4,000.
You said you had the punch list of what needs to be done.
Yes, I have 2 documents that are the rental inspection correction notices, one dated April 3rd, one dated March 31st. And this appears to be the most recent list, and it's laid out by what's been done, and the notes from the property management team as to plan to get those things done by the 20th. So yes, I can email that to Ann.
Okay. And I guess my question is, that list, is everybody operating off of the same list?
Yes.
I think so, yes, Your Honor.
Really? Are we,
I mean,
So-
it's the city's correction order list, so we're working, yes.
is that the latest one? All right. And so the object is to get what's on that list done by the 20th.
Yes.
All right. Mr. Henry, was there anything else?
I don't believe so, Your Honor.
So the issue regarding the working out who's going to be where, how's that? Are you just going to reach out to legal services and try to resolve some of those things?
I'll communicate with legal services, and we can see what information they can provide us regarding the tenants as to their intent to stay or go. And then from there, I think we can have conversations on leases and things of that nature.
And if you have a list of who received those 7, 8 notices, we could probably try and reach out to many of those we can to see what their preference is or what their plan is going forward.
And I'll just make a note to, I don't know that I'll see her this week, but I'll touch base with Judge Washington just so that she's, or Magistrate Bailey, just to make sure they're aware what potentially could be coming down the pike on those. Those, and I don't know if you can, if anybody can answer this, those cases would be filed in the name of Arbor One or the village? How would those cases be filed in the township? Mr. Friedman, do you know?
Mr. Beal's using his other, his regular landlord tenant attorneys for that, Your Honor. And I'm not involved.
Got it.
I'm not aware of it either.
Okay. Then I'll let her know that I have no idea, but they're there. Okay.
Once we establish whether or not tenants intend to stay on the township side, to the extent that they have been escrowing their rent while on the township side, is that rent then being released as rent to the property?
Say that again.
So tenant A, been on the township side, been relocated for a month. There's a COC over there. We set up a lease with this tenant just to kind of establish what's going on. She escrowed her rent for that month. Is that rent now being released to the property?
Okay, so here, that's going to be a complicated answer because theoretically, if there's a case filed at 14B, okay, on the township side, my preference would be to release the funds to 14B court and then let Judge Washington make that determination. If there's been no case filed, and this is where it's really going to get sticky, my feeling would be that once all of that's worked out, then somebody would give me the numbers to just figure it out what needs to go here and what needs to go where. That would be my preference. But what's now being indicated is that there may be an order coming down from the circuit court that all the money is to be given back to the tenant, which means that anything I then have would have to go to the tenant to do with what they need to do. Now, I would see, quite frankly, to try to get a clarification from the circuit court, or have somebody do that, get a clarification from the circuit court as to, in those instances, what should be done.
I think the circuit court order also is a caveat that these monies are being returned if the tenant decides to break their lease and leave. So.
Oh, well, that's wholly different.
Right, so.
What?
That was the point that Ed brought up.
So, okay, but let me ask this, because I'm not sure how one would interpret the order. Is relocating, but then the tenant makes the decision, I'm going to stay I'm going to stay now at this new place. Based upon what's being said, that money, the monies that would be held here go to the tenant and not to the landlord. Or is that not your understanding?
I don't think that would be my understanding. I think the tenant relocating, I think we're confusing two issues right now. So.
Oh, I'm not confused, but go ahead. No.
I think that there are some things with Judge Stunkey's order that are very clear. I don't think there's any dispute that it was decided that if a tenant decides they want to leave and break their lease and leave, that they can do that. There's no issue with them breaking their lease and leaving.
And that's really the breaking of the lease.
Right. So.
But a relocation does not fall in that category.
Right. That's where I was meeting. We were confusing two issues. So a tenant can decide they want to leave. They can break their lease. Harbor One is not going to object. If that happens, they can be refunded money that they've paid in escrow.
Got it.
They can be refunded rent that's been paid since the CFC period until the time they vacate. And then I believe that they would be returned a security deposit if they paid it. If they decide to vacate and leave.
Got it. Okay. Was there any?
Is that your understanding as well? I just want to make sure. That seems very clear.
So it was more of a emergency motion, so as to help the people that were still located in the condemned units to get out as soon as possible.
Correct.
I think that's why it was specific to those people.
Got it. That makes sense. Okay, so now to people who, and again, I'm going to have to see the written order, but to people who are relocated, but then elect to stay, which was basically what Mr. Henry had brought, elect to stay where they've been relocated to. What's supposed to happen with their escrow? And please don't tell me it's silent on that.
I mean, the order did not speak to individuals receiving any funds back unless they were electing to break their lease and leave. So if somebody was relocated, I don't think that this order spoke to whether or not they would be entitled to any of those monies back.
Okay, and let me just say this. Based on what's explained to me, that makes sense, right? However, and I'm just talking technically, but it's not my order, so I don't know how to interpret it. Somebody being relocated, and then the conversation occurs, I'm going to now stay where I've been relocated. By definition, they then break that lease or that tenancy that they had. And so if that's the interpretation of that, then they fall into that same category. Just thought I'd throw that into the mix. But I don't know if that was the intent of what Judge Conkey was ordering.
Cannot speak for Judge Conkey, but my understanding of the hearing is that was not the intent. It was only specifically pertaining to individuals who are currently at the property on the city side who want to break their lease and leave the city side.
Got it. That may be a fight for another day. It just, because it just has to be some clarification on that. And that's going to, part of, as I see it, somebody, somehow or another, there's going to have to be some clarification of that. Because what's going to end up happening is at some point, the folks on the township side are going to file a case.
Look at how I just got max strength generic Viagra for only $1 each from Friday Plans.
And then it's going to be sort of one court for which they may have the money. 14B has a case looking for the money, and the circuit court has issued some order. So somewhere along the line, that has to get clarified rather than everybody scrambling around trying to, at the last minute, trying to figure that out. Bless you, it seems to me. So, anything else we need to, now that I have this update, anything else we need to do prior to me giving the next date?
Your Honor, Todd Ryan, appearing by Zoom. Permission to speak briefly?
Yes, go ahead.
So Todd Ryan, P81848, representing plaintiff prosecutor in the circuit court matter, not a party, speaking as a friend of the court, and informed the court regarding that recent conversation about the scope of the order. That is going back before Judge Conkey as to what exactly was ruled and was not ruled. Both plaintiffs and defendants have submitted proposed orders to the court for the court to finalize. But it was very clear on the record that it did not involve township properties, that the judge was focused, because that's what we presented, on the city side. And for the city side, the judge did orally rule that there wasn't a basis for escrow on the city side with the lack of the CFC. But that was purely for the apartments, and that was kind of a necessary precondition to not ordering escrow on the city side alone. Again, that'll be going back before the judge on some other hearings on Wednesday, so it's very possible the judge
Not ordering escrow on the city side. I don't. Okay, that's fine.
And so with the unusual procedural posture here, with plaintiff prosecutor not being a party before your honor, and their separate claims for the prosecutor than for the tenants, I understand trying to get ahead of it and making the order as consistent as possible. But as I believe Counsel Henry said earlier, this was in the context of a preliminary injunction for emergency relief. And we're going to have a more protracted presentation regarding where the money should go out of that emergency context.
Okay. So are you telling me the circuit court has vacated my order?
No, Your Honor. The circuit court orally found that she would not order escrow on that, and there wasn't a basis to do that for what was presented to her. And she did orally say that the tenants could submit this to district court and to the city of Ypsilanti for that court's consideration. But Your Honor, that may not be reflected in either proposed order.
Of course.
And I do have a recording of the hearing available, but to the extent, just thinking out loud here, to the extent Your Honor had questions to present to the circuit court because they impact your case, I wouldn't make a suggestion on that for Your Honor.
That what? You do what?
Oh, I'm I don't want to make a suggestion to Your Honor about what would be helpful for you. I was thinking of the context of like a certified question, but you know, this is a very different kind of procedural posture with a district court and a circuit court with different parties before each court.
I just called Judge Cookie if I had to try to figure it out. And then once I see a written order, I mean, I don't think on either end, and I would hesitate to say, not speaking for them necessarily, but with Judge Cookie, Judge Washington, and myself, I don't think anybody's trying to make anything complicated. It's just we need to know what to do. And so that everything is consistent. So, and sometimes that may not be the attorney's objective, but I think it would be the judiciary's objective. So, all right, thank you. All right. Did we get a call back on that inspect? Okay. So prior to our next date, I want an indication regarding these inspections so that, and if who is it, CES, if they're willing to put something in writing saying that they can do more inspections, I'd like to see that.
Wix. One platform, any website. Unlimited creation.
And I guess I should clarify. Are they willing to do more inspections and how many can they do a week?
And what's the cost?
Well, we'll figure out the cost. I mean, if somebody's got to put some money in there, what? But if somebody's got to put some money in there, look, folks, here's where I'm at with this. And just how I am. I don't like people coming here telling me why you can't do something. Find a way to get it done, and then let's figure out the nuts and bolts to achieve the objective. Because I'm hearing a lot of sort of naysaying coming from both sides about why we can't do something. And that doesn't make any sense to me. All right. So you guys are looking to have this done by the 20th, which is a Tuesday. And let me ask you this. There would likely be, if you're trying to get everything done by that Tuesday, there would likely be inspections that would be happening that day, is what I'm thinking. Right. So I don't, maybe the next day would likely be the 23rd, which is a Friday, but what do I have on that?
Let me run.
I mean, I could, if I,
You're correct. There's 70.
say again.
We have 70 hearings on Friday this week.
Okay, so, but the 1 week, the 1 week adjournment from the 16th is going to happen, but those have become second hearings. So here's my thought. And it's just a guess. Have we set 23rd first hearings done?
Yes. Yes, we have.
What do those blocks look like?
And 15 second hearings at 10 a.m.
No, those aren't second. Those are first.
Yes, 15.
All right. Set this on the 23rd at 11 a.m. Okay. And council, so that you know, I know we have a bit of a delay, but I'll set it at 11 a.m. on that day. Oh, that's not going to work for Mr. Friedman.
Well, Your Honor, I finished.
Oh, okay. Fantastic. Okay.
I got a certificate of completion.
Fantastic. Congratulations on that, my friend.
Thank you.
All right. So we'll set it on that day. Okay. And then that way we'll see, and I will just let council know you'll be here in person. I will have Zoom hearings going all over the place that morning, but I will try to get them out of the way and make it as least inconvenient for you as I possibly can and get you in and out. Okay.
I will be back in town.
Pardon?
I will be back in town for live hearings.
Yeah, I'm seeing that nice sunny sky behind you.
Yep. It's real.
Okay. All right. Was there anything else from either side then?
No, Your Honor.
All right, thank you. You're going to get that list to me.
Yes.
We can see where we're going to go. And I want an update sent to Ms. Weidling regarding that CES inspections.
Okay. Yes.
All right. Okay, thank you, folks. 14A stands in recess. All right.
Monday.com, the opposite of any work platform we tried in the past. We tried other work management platforms.
This is the time and date scheduled for a hearing regarding money damages in the matter of Daniel Penn versus Pete Edwards and Brittany Baumann. We were here on August 8th. We were here on March 17th for the tenancy thing. And we were here on August 8th and we didn't do very well. The complaint was very difficult to comprehend, unclear. Neither of the parties were very good at Zoom. So I rescheduled the matter for a hearing today, set an in-person trial, directed the plaintiff to file a more specific complaint so we could determine what it was exactly he was requesting. The parties are all present. Mr. Pete Edwards is here. Ms. Brittany Baumann is here, and the defendant Daniel Penn is here. Also present is Megan Bauer from Legal Aid. She's not filed an appearance in this matter and is not, as far as I know, representing the defendants. But she is here observing. Is that accurate, Ms. Bauer?
Well, Judge, this one, I suppose, is on me. We were intending to file an appearance in this case, but we had been waiting for that more specific statement. And I believe Ms. Bauman was hoping and anticipating, based on our representations to her, that we would be appearing on her behalf. I did not realize that this was an in-person hearing either. So if the court would allow me to appear remotely, then I would advocate and represent as attorney of record Ms. Bauman.
All right. The original complaint that I got for supplemental money damages, we didn't get very far. It alleged rent of from 4/2 of 25 of $5,200, electric bill of $1,845, replace windows, doors, and smoke detectors, $307.85, garbage disposal, $400, and other, $4,800, plus damages. The defendant's asking for costs. The total is $12,807.96. So as I indicated, we didn't get far. There was a lot of uncertainty, and so let's start out by Mr. Penn. Would you please raise your right hand, and would you both please raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yeah.
All right. As I indicated, we had a possession hearing back in March, and they agreed to move by the end of March. And
turns out if you've been in a car accident in the past year, they have to give you a huge check, and all you have to.
I gave them a move-out date of March 31st of 2025. Defendant then files this saying that they owe $5,200 in rent. So, Mr. Penn, how did you come up with that figure?
Well, okay, as of 1st of January, that they had paid, there's a little description on a big 8x10 blow up that I got there with the receipt. And they had paid $600 at that point that was applied to the arrears. There's also an explanation on that to Pete and Brittany, which would have brought them up to owing $3,600 at that point in January. Since then, you got February, March, April. It was actually May 7th, I think, before they left. My electric bills escalated.
All right, well, I'm not there yet.
I'm sorry.
We're just trying to figure out the rent figure. Now, I think we determined there was no lease.
Well, I do have an written agreement here. This was written up back on February 9th of 24. And it was signed by Pete, and this agreement says.
Do you have a copy of it?
Pardon me?
You have a copy of it?
I believe you have a copy up there, but I can bring this up, so the original, if you would like to. I can bring it up there.
This thing? Agreement with Pete?
Yeah.
All right, that ain't
That's
much of a
actually
lease.
A photo of this document here.
All right, well, how much was rent supposed to be each month?
$800 a month.
All right, agreement with Pete. Pay $700 for last month electric plus $300 a week until debt is caught up from rent due of $800 per month due for January, February for a total of $2,300 in arrears. There's no date on this. Signed. No, he didn't sign. Yeah, Pete signed it. Tenant. All right. So just rent. Do you guys agree that rent was $800 per month?
It was supposed to be, yes.
All right. All right, how did we come up with 5,200 for rent?
There would have been, I believe there was an explanation on there. Part of that was a couple $100 a month toward the electric, that usage that they was responsible for their their electric usage. And this electric bill just escalated up to near
We'll get
$900.
to the electric bill in a minute. You're the plaintiff.
Yeah.
And you have the burden of proof.
Okay.
So you have to prove to me beyond a preponderance of evidence that they owe you this money.
Right.
So I'm trying to help you, but I ought to just say, all right, but you're not doing very good. I haven't even figured out how you calculated how much the rent is. We haven't even got to the hard stuff yet. So don't talk about anything other than rent.
Okay.
You came up with $5,200.
Okay.
All right. Where did you get that number?
$800 a month. Last money that I received from them was on January the 3rd. And she gave me $600, and that was applied to the arrears. That was from January or 11/1/24 to 11/30/24. At that time, she had that their rent due was $2,200. They paid $600 that date, and that was applied toward the arrears, and that left a balance of $1,600. Now, December.
Celebrate Zaxby's birthday with half-off handcrafted milkshakes. Who's got the sauce?
Zaxby's. Imagine being able to build an app with your name on it, just by thinking about it. Meet Base 4.
January. December was due. January was due. That was applied back toward 11th month. So that left December due $1,000. That was $800 plus $200 for electric usage. And then January 1st, another $1,000 was due. And
All
that
right,
would
you're
have
already
been
throwing me a
considering
curveball.
1,000,
All right,
200.
so rent is 800.
Yes.
And then there's 200 more for utilities?
Yes, gas, electric, yes.
But you have no lease.
Pardon me?
So where'd these numbers come out of? You just pulled them out of the air somewhere?
No, this right here, $800 a month was for the rent.
All right, where's the $200 for utilities?
Well, this was an agreement that the electric bill varies depending on the usage.
All right, well, I'm still trying to figure out how we got $5,200. You've got some arrearage that I don't understand what it is, but let's just assume that it was correct. It was $2,200. They paid $600, and then you were fumbling around. So as of January 1, is it your contention that they owe $600?
They paid $600 on the 3rd.
All right, so so on that date, the amount due is $1,600 as of January 1?
As of January 1. As of January 1, it went to another $1,000.
All right, we can't do $1,000.
Okay, let's go $800 then.
All right.
Let's knock it down.
All right, well, how much rent was due on January 1?
I will have to say $3,200. Taken off the the electric off of me.
Well, you said rent due was $2,200. They paid $600.
Yeah.
Which left a balance of $1,600.
Right.
As of what date?
As of what date? That was on, they paid, that was on that was on 1/3/25 that they gave me the $600.
All right,
I
so-
applied it to the rears.
All right, and so you said what was due then was $1,600.
Yes.
All right.
Yeah.
All right, so let's operate from that. Now, you're asking me for $200 a month for electric, which isn't in the lease, plus you're asking me for the electric bill. So you're double dipping, but let's just work on the rent. They
Okay.
agree it's $800. So let's assume that as of January 3rd, it is $800. So we'll go through as of Jan 1. All right, did they pay rent February, March, April, January, February, March, or April?
No.
All right, well, let's start with the first, no rent, January, February, or March. Now, they were supposed to be out by March 31st.
Right.
They were not?
No.
When did they vacate?
It would have been about around the April 7th. They had to come out and give it, I think officer came out and give another eviction, told them they needed to be out. And they had not given my keys back or
All
nor
right,
have they
Ms. Bauman or Mr. Edwards, when did you,
I have a picture.
what day did you vacate?
We vacated on the 31st, like we were supposed to.
Okay.
I actually have pictures I took of my animals in the motel room on the 31st.
Okay. So if 1,600 is due, we have January, February, and March, which is $2,400. 800 times 3. That makes $4,000 in rent. Do you agree no money was paid after January 1?
I do agree of that because we were trying to save up so we could move out because we had gotten the eviction notice.
All right.
So we had not gotten into an apartment yet. We had not gotten into anything yet. So we were trying to save up as much money as possible because it was still cold outside.
Okay, you answered my question. You didn't pay any. All right, let's talk about the electric bill. In the complaint, you've got $1,845.06.
To the early risers, work through lunchers, and emergency call answerers. To the party savers, holiday disaster averters, and DIY fixers. At Supply House, we make sure you have everything you need to get the job done right. Because when things get tough, you get tougher, and you're built for this.
Where'd you get that number?
Those was based off my electric bills, 700. I think I gave you some photos of the actual billing that I paid. Since they was there, they ran up the electric bill because it was actually burned up my electric stove heating the place with
All right,
it.
I don't, just tell me where you got the number. How did you get 1,018.4506?
That was just based off of,
Well, I'm not your accountant. You give me a bunch of pictures of stuff off your phone. So what adds up to 1,008.4506?
well, if I took, half of the, if I paid half of the $700, $800 electric bills, there was like 3 or 4 of them. And they would be responsible for the other half. It comes out to pretty well that.
How is that? You paid half and they paid half?
My electric usage usually never was more than $200 a month. Okay, that went up because of they was heating with electric instead of putting the propane in the tank to heat the house with the furnace. So that's what drove the electric bill up. And in the process, they burned up a stove because they're not designed to heat with. And there's a picture of that got so hot that it melted the window, the motherboard in there. And that's also what was blowing the.
All right, well, you give me 3 electric bills. Is that what these are?
Yeah.
January 7/58/11. February 19th, 7/58/11. And March 20th, 7/96/95.
Here's another one. Maybe you didn't get this one. It's 3/13 for 799.94. And it shows that I paid that.
3/13/25.
3/13/25 was when I paid the electric bill for that. Usually do the 18th, so if I don't pay my electric bill, they shut me off.
I don't see, I see when you paid it, but I don't. And here's another one, January 21st, 4/14/93. $758.11 times 2. 796. Just a minute.
Yep. $1,211.80. Yes? Have the defendants received copies of these pictures that you're looking at?
No, I did provide them to them to view prior to the hearing, but he did not serve a copy of any of this on that.
I suppose to preserve the defendants would object to their admission, just to preserve that objection, I guess.
I'm inclined to just let Mr. Penn suffer his losses, but the pictures show a pretty deplorable circumstance here.
Judge, can I ask Mr. Penn some questions on the record?
Yes, Mr. Penn, I've been trying to weave straw out of gold here, or gold out of straw, but I'm making straw out of gold. Your pleadings are so poor and you're so inexperienced in this that I'm very struggling. However, my struggle to help you can't go to the detriment of the defendants. You can't even answer a simple question like how much rent is owed or how you got the figure for the electric bill. Ms. Bauer is placed an appearance on behalf of Ms. Bauman. And she's going to ask you some questions and you're going to have a hard time answering them because you couldn't even answer my softball questions, but you are under oath. Go ahead, Ms. Bauer.
Thank you, Judge. Mr. Penn, is this property on Finley Road?
Yes.
How are there multiple building structures on this property on Finley Road?
Yes.
Judge, I'd like to request permission to share my screen.
Yes.
You know what's in your cheap protein powder? Well, here to tell us is all-natural fitness athlete Paul Sklar.
All right.
Mr. Penn, can you see my screen? Is there a picture in front of you of your property on Finley Road?
Yeah, it looks like an aerial view.
Okay. And is this where the tenants lived?
No, they lived up in the apartment, above the garage.
They lived in the apartment above the garage.
Yes. The other building to your left.
This one right here?
No, up higher. Right,
This one?
right there. Yeah.
This one right here.
Yeah. That building there, yes.
And isn't it true that the furnace did not work for the upstairs apartment at various times throughout this tenancy?
That is not true. It did break down and I had a technician come out, analyze it, and he replaced a gas valve in it. And he fixed the furnace, but the furnace needs propane to run.
Okay. And isn't it true that a water pipe supplying the apartment or area upstairs above your garage broke several times?
It froze and broke because there was no heat coming from the furnace downstairs, which kept the downstairs heated.
And as you
All right,
and
let me
Mr.
what's downstairs under this apartment?
Well, the
Garage and wood shop.
the garage, the shop, the furnace is down there, the water pump, all the plumbing. So that has to be kept heated to prevent pipes from freezing.
And so, as you indicated on the record, there is no lease that obligates the tenants to pay for propane, right? Do you have a lease?
Well, let him answer the question.
that was discussed with them. There's a separate propane tank out there.
All right, that wasn't the
Yeah,
question.
actually-
That wasn't the question.
Yeah, well,
All right, do you have a lease that says they had to pay for propane?
no, I don't have a lease.
All right.
Not a written one, other than.
All right, that
that
answers the
agreement.
question.
Okay. And you testified a minute ago that that furnace runs on propane.
Correct.
And you also testified a minute ago that, or you alluded a minute ago, that when there is no propane, there is no heat. And because there was no heat, the pipes froze. So the pipes did freeze?
Yeah, the pipes froze.
Okay.
No, that's why I had to shut the water off, because water was running right down on my.
Just a minute, I didn't ask you, you'll have a chance to speak.
So you did shut the water off on these tenants then?
I had no choice. If water was running down, yeah, I had to go shut off the pump, yeah.
Okay.
Yeah. Because the water pipes was frozen, you can't just let the thing run with frozen pipes.
Now, there are unfinished walls inside this apartment above the garage, right?
Okay. I'm not sure what you're asking me, but
Okay. Is there exposed drywall in the unit that you rented out?
there was some, and Pete had agreed that he was gonna finish painting that up when the, and I was gonna knock it off the rent. But he never did when they replaced the roof back last year. And replaced the flooring and the door and the sidewall and stuff. So they did all those repairs, and then Pete said that he was gonna finish off any painting of that room. So I'm like, okay, well,
It was painted.
I didn't have a problem with that.
It was painted.
He would
All
have
right,
been
you just-
compensated for it if he would have done it, but he did not
Mr.
even do that.
Edwards,
I'm sorry.
if you were in a Zoom, I'd mute you. You'll get a chance to speak if we even get that far.
Right.
Let me ask a couple questions. Does the township know there's an apartment above this garage?
Well, I'm sure they probably do.
Is there a separate septic system for this
There is
apartment
a separate septic system.
and a separate well?
There is a separate well, yes.
All right. How long has it been there?
Been there for years. I just took over the farm back in '08.
Yeah,
And
if
it
this was
already,
you can't generally put two residences on the same piece of property.
really,
And in this, well, you've got two wells and two septics, so maybe that's permitted. You certainly couldn't do this in the city of Three Rivers or Sturgis, but out in the townships, there's not very strict zoning enforcement. In order for them to heat their apartment, they also had to heat your garage and workshop downstairs through the furnace. And there is no provision that they pay utilities. When you don't have a lease.
Look at how I just got max strength generic Viagra for only $1 each from Friday Plans.
You don't have the protection that a lease provides. You're talking about, well, there was a verbal agreement for this, there was a verbal agreement for that. This isn't small claims court. This is general civil court in a landlord tenant proceeding. And in true point of fact, this place is probably not even legally rentable. It certainly wouldn't have passed any code inspection. And
Judge, we haven't even asked about the chicken coop yet.
um,
And the electric usage. But ultimately, the defendants would argue that Mr. Penn is not entitled to a single penny more than he's already received, because throughout the course of the tenancy, during which rent was paid, there were periods of time without water and without heat. He had a duty as a landlord to supply heat, and he didn't. Whether that was through propane or because the furnace needed to be repaired. As a landlord, he had a duty to supply water, and he didn't. Whether that was because he had failed to supply heat or because he's failed to have this well tested for water safety, or any other reason. The tenants were without water for an extended period of time. The tenants were without heat for various periods of time. This unit is an
all right, well,
an
let me ask
unfinished
you,
unit.
let me stop you for a minute. Ms. Bauman, during that winter between January and when you vacated in March, how much of that time were you without a furnace?
Pretty much all winter. And I have several messages printed
All
out
right,
here.
how much of that time are you without water?
Since I do believe it was December. It was more than a few weeks. It was over a month. We had to buy several water bottles. Or jugs of water. We had to boil water to take showers. We had to boil water to.
How did you flush the toilet?
We had to take a water jug and dump it down the toilet.
All right, and that was in January? For how long?
Well, I think it was December. We were out without water. It was quite a long time.
Okay.
We had to spend a lot of money just to buy water, just to take showers and to do dishes and to water our two dogs.
And Ms. Bowman, did you pay for propane at various points in time?
Yes, we did. We did, and I have called to get the proof of that, the receipts of that, but they said that they could not. I'm not sure where I'm supposed to be looking because I can't see you. But they said that they could not send me proof because every single receipt was in Dan's name because he did not have it put in our name. So there's no distinguishing who paid what. So they could not send me the receipts because they were all in Dan's name.
All right. Could you take your screen share down?
Oh, I'm sorry.
Well,
Judge,
leave it up for a minute. Mr. Penn, do you live on this property too?
Do I? Yeah. I live
All
there.
right, so they live above the garage and then you live in the house?
Yes, correct.
Okay. What are all these cars on the property?
Oh, there's some of them that are just broken down.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11,
Been
12.
getting rid of some of them.
All right.
It just sometimes it accumulates through the years. I do have a video here that where the pipes was frozen and broken.
All right.
And it was time stamped.
Would you?
Meg, would you take the screen share down?
Yes, Judge.
Thank you. Okay. Go ahead. I don't need to see it. Ms. Bauer has convinced me. I don't want to be your enforcer for $12,807.96 for this untenable tenancy with a not lease written on a piece of 5.5 by 7-inch paper. That lease did not require them to pay utilities. You had an obligation as the landlord to provide heat. You also had an obligation as a landlord to provide water. You're charging them $1,000 a month because they're in a residence of last resort. When in true fact, this property could not be rented if it had to pass any sort of an inspection. So the rent component is zero. The electric bill is zero. You failed to provide propane. And because of that, they had to run electric heat. They had to pay for water. This tenancy is so poor.
Apartments.com helped me find a place I never want to leave. And neither do my friends. Find your place on apartments.com.
So think of it as like a TV ad with a catalog component where I can choose on the Roku app. And
now, granted, they didn't exactly treat it with, they left junk all over the place, and it didn't look very great, but I don't find that you've met the threshold of providing basic covenants of habitability. And we could spend 5 more hours exploring that. But you either need to get this property inspected and allowable as a tenancy, or get out of the landlord business. But I find that damages are zero. This is a hard lesson learned. You got into this thing without following the Landlord-Tenant Relationship Act, without understanding the obligations of the landlord. You got into it because you didn't have anywhere else to go. But I'm not ordering that you pay anything. I did remove you from the premises, which is something that had to happen. But money damages are zero. All right, yes.
We were not removed. We moved out on our own.
Well, he started the termination of tenancy.
Yeah.
And then we talked and you agreed to move, but
Yeah.
absent that, you probably would have been there longer. But I can't, there's some minimum standard that I don't know what it is, but we haven't met it. All right. Mr. Penn, let me repeat, you need to get this thing up to code or get out of the landlord business, because this costs you a lot of money. All right, if you take Mr. Penn out to the counter, you can get a copy of this. I'll hold on to this, just take him on to the order.
Thank you, Judge. Ms. Baumann.
We were trying to determine how many angels could fit on the head of a pin when there's a basic fundamental failure to provide habitable property. Oh, yeah, he's coming to get it. And then when he leaves, I'll have the other party go out. All right. I don't know what kind of shape it was left in, but hopefully you found a better tenancy than this for $1,000 a month. All right. Why don't you wait about 5 minutes and you go out to the counter and you can get a copy of the same thing.
Can I say something?
No, we're done. He didn't get any money. You guys.
Sparrowwood Apartments versus Regina Agnew. Hello.
Hi, Your Honor. How are you?
I'm good. All right, where are we on her case?
Your Honor, I have a balance of $1,505.
Okay, she paid the 1646 or whatever.
On Monday, yes.
On Monday, got it.
You know, I don't understand why Robert, hopefully you're watching.
Pardon?
Not you, Your Honor. First, let me state my name, Regina Agnew.
Thank you. I was gonna ask, but you seem like you.
No, I'm really under a lot of
Okay.
stress. My asthma, it's just really been bad. I've been off work on a medical leave, and I explained it to him. I even explained that I was hospitalized, and I'm doing the best that I can.
Right.
I'm waiting on medical payments. And when I spoke with him on Monday, before making the payment, I said that you had stated in my Zoom last week that to see if I can work something out with with
Right.
people at the office manager. Excuse me. So
Just take your time. Okay.
So I said that to him. So because we're in September now, so September is due, obviously. And so he told me to, well, that's something that our attorney would do. I said, well, so then I told him that I'll come in the office because I had a follow-up appointment from being hospitalized with my primary doctor on Tuesday, but I didn't make it in the office to see him. I'm trying to get myself together because I miss making the money that I make, So I didn't make it into the office to have a conversation with him. And he's not so easy to have a conversation with because I can say to him, like you recall me a couple months ago in here, I said, I can pay, this and that amount. And he'll say things like, well, who else do you have to pay? That's none of his business, and I already feel like I told him he stresses me out. Communication is everything. And when I try to have a conversation with him, he likes to really kind of, well, the owner said that they're not going to renew your lease. Well, the owners act like I live in the Hamptons, with the old vintage closet doors and bulky paint on the wall. So since they bringing me to court, because I felt like he really didn't have to bring me to court because of course, yes, I need a roof over my head. I'm going to make the payments. I'm not a freeloader. I like nice things in life, but the way that apartment look, no. That does not equate with what I like. And here it is. I'm here again. Why can't he just work with me? And they already do this and do that. I'm at the point where I feel like I already spoke with my benefits rep, UAW Legal Services, where I need to get me an attorney. That's something have to come out of my pocket. So I will. That's just something grandkids won't get for a little minute, It's all right. But the way he says to me, we pay $1,000 to take you to court. Well, don't take me to court.
All right.
I pay my court costs. And I'm saying all of this, Your Honor, to say the moral of it all is he is not easy to work with. And I need my reserve oxygen, seeing that he's not, being accepted and grateful for it.
So let me ask this. 1505, when do you think you can get that
The
paid?
26th. I told him
pay-
that I can make that payment.
Okay.
It could be paid by the 26th. And that's when he said, well, I don't know. It depends on what my attorney says.
Well, doesn't matter right now what they said because I'm adjourned. Can you get it paid early in the day?
On the 26th, yes.
Okay.
Yes.
So I'm going to adjourn this case out to the 26th because I'm going to have the final say. That'll be at 3 o'clock.
Thank you. I appreciate you. I really do.
Thank you.
I really appreciate you being a fair judge. You're stern, but you're fair.
Stern?
Yes.
Is that a bad thing?
Oh, yeah. Not at all. Okay. No.
Alan told me to be that way because I wasn't that way.
Seeing that I have to be on your docket, I prefer to be on this docket than a criminal docket,
That's probably true. All right, so get the balance paid by then.
Okay.
And if you have everything paid prior to that point and you're sure you got everything paid, you don't need to appear.
Okay, good, because I'm released to return to work in another week. So
Okay. All right. So let's see if we can get that done, get it worked out, and then they'll just dismiss it if you get it.
Okay, thank you.
You have a blessed weekend.
God bless you. You have a blessed one as well.
Timbercrest LLC versus Vereen Willen.
Ready, Your Honor. 11694, appearing on behalf of 9105 Timbercrest.
Her name?
Doreen Whelan.
All right. And where are we on this, folks?
Yep, we're here for the second hearing, the first being August 29th. And at this point, we are here seeking a land contract forfeiture. I have the judgment. They had a typo on it, so I've marked it up a little bit. I understand through a couple of text messages I received that Ms. Whalen may have a buyer, so we are less than 50% if we can get the judgment and start the clock on the 90 days. Hopefully we can get it taken care of without forfeiture.
Correct. I have a old friend of mine who owns a business and real estate, and he buys homes, flips them, resells them. So he's willing to get an appraisal on the house and see how much it is worth. And then he wanted to talk to Joey about purchasing it from him. But he's been in contact with Joey, the owner of the house, and he is on vacation right now. But when he comes back, he gave him a link saying that the house is worth 400 to 500,000. But the person that I had come appraise it was less than 350. So I don't know what's going on with that right now. So he's gonna get his own appraiser to see how much it is worth, and then if Joey is okay with it, he would like to purchase it from him for me.
That's a deal they can work out during the 90 days. We
Yes,
have an
correct.
amount due and owing as of August of $398,249.06 plus some court costs, bringing the total to $398,617.56.
Have you looked over the judgment, ma'am?
I have.
All right. Do you have?
No, she said she has, but I've never shared it with her, so I know that's not true. So let me do that, please.
Okay.
Well, here.
I don't know if it's in. No, that's not the
We're
judgment.
talking about the paperwork for the
Yeah,
court.
it's a complaint.
No.
This is the judgment, so. There wouldn't have been a judgment included. This is the complaint. It shows the amount as of, like I said, August 8th, and then the court costs. So the forfeiture number is $398,617.56. That included court costs of $368.50.
Okay. Yeah, okay, he's just, okay. Well, that was up at 8.
Right.
I have.
It's actually probably a little more than that now, but,
Yes.
you know, and whatever deal they make, they can make, but I mean, she has the right to sell it, and we'll release our land contract in the event that the amount's paid. And I do know of this proposed buyer because Mr. Zago reached out to me from Austria yesterday and said, it's in your hands, deal with it. I'm not seeing any paperwork. I don't know how real or unreal it is, but there's no reason to keep forestalling.
Okay. Do you have any objection to the judgment, ma'am?
No.
I'm a bit concerned that as you were looking at it, that you weren't really looking at the judgment.
No,
Yep.
looking at the numbers, because I was looking at the numbers here. They were little, I mean, they were scribbled out a little bit and looked different from the numbers I had here, but
Right, but I guess I want to make sure that you understand that the land contract is being forfeited. You have basically a 90-day period in which to redeem the property. So if there's a deal that works out that sells it, that's one thing. If you come up with the funds to pay it, then you can redeem the property and keep it. You understand that?
yes.
Okay. Is there anything about the judgment that you don't understand?
No, this has just been super stressful. I ran into something I probably shouldn't have gotten into. Joseph was like a family to me. He purchased the house for $270,000 cash for me so I can move in. I went to training for Delta for 8 weeks. When I returned the house, he put carpet in. It was furnished, which I was unaware of. It was supposed to be a surprise. I was supposed to be living there for 3 years until I got back on my feet from not having a job, being a single mom of 5 kids, to just now getting a new job. And some things happened. So that was August of 2023. September, I found out that the house was infested with snakes, and Joey no longer wanted to deal with it. He said the house is nothing but pain. You either buy it or you have to find another place to live. So
That's what happened.
that's
Okay.
how.
All right.
I'll mark if I can send.
All right. Ma'am, you are unrepresented by counsel. I would have to advise you that you do have 3 business days to think about this. If you believe that there's some legal reason, some confusion on your part, some misunderstanding, or some non-assertion of any rights that you have, you'd have to file a motion with the court within that time frame. You understand that? All right. Doesn't mean I would grant it, but you have that time.
Thank you, Your Honor.
Thank you. Glencoe Hills versus Garzita Herrera.
Julian Engen, the plaintiff. Good afternoon, Your Honor.
Well, it's an afternoon. I don't know how good, but thank you. Hello.
Hi,
Your name?
Yarisa.
Okay. Where are we on her case?
I have a balance due to court costs of $1,545.40.
All right. And how are we getting this paid off?
So we're still working with Section 8 and the VA. I'm trying to get a face-to-face meeting with my specialist because there's a lot of phone tag and I'm not getting a response from her as far as my adjustment that needs to be made from that loss of income from VA. Now, they did call me today. Legal.
The VA did?
Yes. And all they could say is that they do have an insurance policy for the kids, but that I need a copy of his death certificate and my son's records. So I'm trying to get the death certificate. I don't have that, so I have to figure out how to get that, which I don't know why I need it because he's been getting those payments for years. So the appeal is still in process with them.
Okay.
I've been making my rent payments every month. Section
No, I know.
still makes their payments too.
All right. And we haven't resolved then the recertification issue with Section 8, right?
It's my understanding that it was resolved with Section 8, but that
I'm not aware of it.
at the last hearing, the notes from my client say that Misty from Ann Arbor Housing had said the portion correct, but I don't know if that would also.
So this amount though isn't really going up per se. If you're paying your rent, your monthly rent, Section 8's paying.
Right.
I don't know how that can be correct because I lost $710 from the VA. So if Misty is
and because of that loss, her portion should have gone down, right?
yes. And the award letter that I have from June with Section 8 still reflects that old amount with the 710 added.
Got it.
Okay.
So it's actually the children's benefit payment, right?
Yes.
So that's, I think, really what the issue was, as I'm remembering it. She's no longer getting the benefit, should have been recertified. Her portion should go down because that income isn't there. And she's appealing that, but
Social Security said it takes up to 6 months.
Excuse me?
6 months. Social
said that?
Security. Social Security. And it took me almost 2 years to get the benefits after he passed. The other children are still getting it, but I don't know what happened with my son. They're in a different county though, so I don't know if that makes a difference.
Sure. Here's what I'll do. We need to check that number to make sure that that's correct regarding the recertification. You're meeting with some folks.
Misty, my specialist.
I got it. I'm going to adjourn this out 2 weeks to the 26th, 2025 at 3 p.m. And let's see what information we have at that point.
Okay. Okay, thank you.
Have a good week.
Seeing you. Oh, yes, I did. The intake specialist said that they won't have fundings until October.
That's
But
if they have it then.
she said I qualified, they just don't have the fundings right now.
Right, okay. All right, that's actually good to know. Okay, thank you.
Okay, thank you.
Gulfside Lakes versus Patrice Haywood. Oh, there she is. She's always so quiet. Hello.
Patrice Hayward.
All right. How much is owing on Miss Haywood's case?
Jillian Egan for plaintiff, Your Honor. I have a balance including court costs of $5,536.45. I see a note from, I think there was a plan for Ms. Haywood to pay half the balance from August by the end of the month. I don't see that that's been paid.
Okay, what happened?
I don't remember.
I don't know that was, I don't have a note of that. I had that she was gonna pay, back in August, she was gonna pay 2,000 by the 28th. But since then, I don't see any, my notes don't show any.
I think that was my understanding as well.
But it looks like she did do, maybe. All right. How are we planning on getting this paid off? You know?
I have my second appointment with Hawk on the 23rd. And I'm supposed to try and bring my balance down as much as I can before that appointment.
Right. But you'd have to get 2,500, almost 2,600 in to bring your balance down to a level that they'll pay. All right. Have you tried to work with the landlord on this?
No, I haven't. No.
And Hawk is, the reality is they're out of money. So they're not going to have funds there. So what I'm going to do, because we've got to get this solved, well done on hearings. We're going to find after hearing, finding no tribal issue, I'm going to issue a judgment for possession for the 553645. But a writ won't issue till the 29th. So basically, Ms. Haywood, I'm giving you to the end of the month to try to get something figured out. Okay?
That's fair.
All right. Thank you, ma'am.
Thank you.
Hamilton Crossing 2 versus Veronica Whitsett.
Jillian Egan.
Hello, Ms. Whitsett. How are you?
I'm well, and yourself?
I'm doing fantastic. All right. Where are we with Ms. Whitsett's case?
Your Honor, I just checked in contact with my client. I don't know if I have an answer. Okay, I don't have an answer. Your Honor, I have a balance including court costs of $1,416. Ms. Whitsett and I spoke before court. She stated that she could have that plus October rent on or before the 6th of October. Your Honor, I think I'm okay if we adjourn this one. I'm sorry, Ms. Whitsett, if we, is that okay with you? So, Your Honor, if
She
you would.
just likes coming back to see me.
I do.
September 19th, 2025 at 2 p.m.
All righty.
All right. Take care. You have a great week. Court calls the case of Hamilton Crossing 2 versus Brandy Colston.
Hello.
Hello. Your name?
Brandy Colston.
All right. Where are we on Miss Colston's case?
I have a balance including court costs of $500.75.
Hi. I think Hope's gonna pay it for me.
Who?
Hope. Because I had an intake with the person already. I signed my papers. But I think the problem is that I told them my next court date was the 19th. So they said they would definitely have it paid before the 19th. But and then I got the mail. My court date was today. So, but yeah, I already have.
You just told them a different day.
I know, right? But and then when I got the letter in the mail, I said, "Oh man, it says the 12th, not the 19th."
All right.
But yes, but I already
I
signed my
can
paper and
I can
everything.
resolve that easy. I'm just going to adjourn you to the 19th at
All right.
2 p.m.
Okay.
All
Thank
right.
you.
And so it better be here.
We just made it.
Don't coming in here telling me, oh, I told him 26.
I know, I'm not this time. No, it was my fault. Thank you.
You're welcome. Hamilton Crossing 2 versus Trayvon Weatherspoon.
Jillian Angus for plaintiff.
Good afternoon, Your Honor. Andrew Campbell on behalf of the defendant. My client is present and standing to my right.
All right. Your name?
Tobias Weatherspoon.
Hey. Sorry. Where are we on this?
Your Honor, so we are likely to resolve this with a conditional order of dismissal. Ms. Weatherspoon had lined up funding to cover the majority of her balance. There is an issue. There's a missing $500 payment that Ms. Weatherspoon says she paid through the portal on credit card. My client doesn't see it on the portal, and so we just want to resolve that before we put any sort of terms together. But I think that this is headed to a COD.
That is correct, Your Honor.
All right. How much time do we think we need to? Will 2 weeks do it or a week? Which
2 weeks is fine, Your Honor.
during this to September 26, 2025.
Thank you, Your Honor.
All right. Thank you. Thank you.
Can I say something?
You want to talk? You want to talk to me?
Yes.
What if I said I don't want to talk to you?
I don't think you would say that.
I wouldn't say that?
No.
Right. Go ahead, Ms. Weatherspoon.
No, but last time I was here, you said that it will, I had the 2 promissory letters or whatever. I just want to know the next time on the 26th, can I appear in Zoom?
You'd have to submit the form and I'll
We
certainly.
tried to do it this time, something.
And what happened?
Wrong.
That was my fault, Judge. I did submit the form and I did everything correct and I got confirmation. I just don't know how to read it because I'm new here and I didn't know the asterisk meant I couldn't appear. I apologize to my client and to the court.
Okay, so you want me to solve something he did?
Yeah, I'm sorry.
I'm sorry. He explained to me, he apologized, but I want to, because the first time I was supposed to appear through Zoom, it went wrong. So I was like, maybe he's just doing that because it went wrong the first time. So I want to.
I'm sorry.
I got 2 little babies.
No, it's okay. I got you. Just submit the form. I'll consider it. If it was submitted for you to appear via Zoom, we'll figure it out. Just appear.
Okay. Thank you.
Sorry, Your Honor. Thank you. Sorry. Sorry. No, thank you.
Miss Weatherspoon just wanted to yell at me. It's all right. Hamilton Crossing 2 versus Tiffany Roots.
Jillian Angus for plaintiff.
Hello, Miss Roots. You're stationary, I presume? Okay, you're muted also.
Okay, can
Thank
you hear
you.
me now?
Yes, ma'am.
Right.
All right, where's the status of her case?
Honor, I have a balance including costs of $2,761.
Did you get the $400 in or no?
Yes, I did. I paid a payment of $500.
You see that?
I don't. Ms. Roots, when was that made?
That was
When did you pay that?
It was made today. I have a receipt here.
Oh, okay. So, no, it's okay. Like I can read that little print from here. Anyway. She's gonna hold it up like I can. Anyway. So that would take 500 off of that, so about 22. How are you gonna get the rest of this paid, Ms. Ruth?
Okay, so I had a bunch of things lined up. Hawk, I spoke to them. They're out of money. Friends Indeed did agree to pay 500, but I have to pay down the total amount first. Department of Human Services, I am working with them. She was denying my case based on, she said I lived in unaffordable housing, but she did not give me an opportunity to even upload my documents. I did get a job, and I uploaded the working with her. With that, my job starts on the 22nd of this month. I have spoken to Neighborhood Peace and they are getting back to me.
Neighborhood.
Yes. And I have also called the assistant manager at the apartment complex here at Hamilton Crossing so that I can get put on a payment plan just in case any of these things do not come through. So I do have another payment that's going to go in this upcoming Monday in the amount of $500 again. And I intend on continuing my payments of $500 every week while I wait on these other agencies to come through.
So you're at 22, you're gonna pay 500 on Monday.
Yes.
Then your next payment will be that following week on Monday?
Yes.
All right, here's what I'm gonna do. Because she's got a lot of irons in the fire. I'm gonna adjourn your case to the 26th. 2025. I'm going to expect $1,000 before the 25th to be paid on this account, at least.
Okay.
Okay, that includes, so you have 5 and 5.
Okay.
And so that'll put us down near a manageable number. And maybe we can get you to the, with nothing else comes through, that $500 threshold that Friends and D to take care of the rest.
Okay.
You see what I'm saying?
Yeah.
We may not quite get there. My math doesn't quite add up, but okay, that'd be the 26th at 3?
Yes.
At 3 p.m.
Okay. And can you tell me again, what was the total amount due? You said 27?
It was 2761. But that does not include your 500.
Oh, good. Okay.
So it's 2261 really.
2261. And you said on the 26th at 3 p.m.?
Yes, ma'am.
3 p.m. Got it. Thank you.
All right, thank you. Here on Vista Apartments versus Tisha Clark. Hello.
Hello.
State your name.
Tisha Clark.
All right. And where are we on her case?
I have a balance including court costs of $2,136. Your Honor, if you would adjourn this to next week, I'm trying to get COD terms finalized with my client.
Got it. Is that okay with you?
It has to be.
What'd you say? Do I have to be?
I said it has to be.
Yeah. Okay. Yeah, you're right. You're right. Well, it doesn't have to go that way, but you don't want it the other way. It's September 19, 2025 at 2 p.m. Okay. Thank you, man. Here on Vista versus Giovanna Nesbeth.
Jillian Engen for plaintiff.
You do great every
She's a-
time.
What'd you say?
I said you do great saying my name every time.
Thank you. I like, see, Alan, and I said her name right. They are giving me, never mind. I'm not talking to you guys anymore. No, I'm not talking to you anymore. Somebody gives me a compliment and you guys get all like, whatever. All right. What's her account?
I have a balance including court costs of $3,721. I think Ms. Nesbeth is, Nesbeth, are you participating in the forgiveness program?
I am, and I did speak to Sheena, which is the manager there. And I'm supposed to be paying. I'm waiting on it to deposit, which is where I'm going right now. $700 to $850 today, and then $500 next week as well. She told me to send dates via email. So.
Okay.
So you want me to adjourn it out? All right. I'm going to adjourn your case out September 19th, 2025, 2 p.m.
Okay.
All right.
Thank you.
Thank you. See, you guys don't. Nobody wants to give me credit for what I do. Here on Vista versus Keandra Hawkins.
Jillian Engen for plaintiff.
I'm here.
Okay. All right. There you are. Okay. And how much is owing on her account?
I have a balance including court costs of $2,876.
Okay. And Ms. Hawkins, how are you intending on getting that paid?
I'm on a payment plan. They told me at the last court date that they just had to get something in writing, and it was supposed to
The
be closed.
paperwork in.
Yeah.
So you're on the forgiveness plan?
I don't know about a forgiveness plan, but it's just something that my manager and I came up with, and she gave me a paper. I signed it, she signed it. So at the last court date, it was supposed to be dismissed, and then he said he had to get something in writing, and then at this court date, it was supposed to be dismissed. So I don't know what's going on with that, but I thought we were supposed to be dismissing it.
I don't either,
I
but
think it's $750 every 2 weeks.
Mm-hmm.
Okay, Your Honor, I'll get that in.
okay. So what I'll do is I'll adjourn it out one more time, 19th at 2:00. And when you said you didn't know anything about forgiveness, if anybody's offering forgiveness, take it. You have a good weekend.
Okay, so in a week, I can come back on Zoom because you see where I'm at, right? I'm at work.
So am I. Why?
And you're on Zoom.
You always do this. Yes, just put it down for Zoom so I don't have to be yelled at. Nobody else you took up everybody else's Zoom. Everybody else got to show up.
Thank you.
Take care.
You too. Bye-bye.
Investors Realty Group versus Timothy Stevens.
Your Honor, for the record, Daniel Landsman, P35797, appearing on behalf of the plaintiffs.
Ethan Cherry on behalf of Timothy Stevens, requesting permission from the court under Rule 8.120.
Hold on. What, you just making up your own script? You're reading something.
I was a little nervous.
No, come on. Santa Croce would have told you I'm a stickler about this. Go ahead. Try it again.
So Ethan Cherry on behalf of Timothy Stevens, requesting permission from the court under Rule 8.120.
Requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of
David Santacroce.
Okay.
Plaintiff does not object as long as there's no AI involved.
Yeah, okay. Permission to practice is granted. Yeah, that's because he's got that other M and not the real one. All right. Okay, where are we on this case?
Your Honor, I just received the answer from Brother Counsel. It does not appear to raise any type of tribal issue. There is currently a balance of $3,064 and costs of $214 for a grand total of $3,278.
$3,278. Okay. And what is defendant's position on this?
We're requesting an adjournment. Mr. Stevens applied for SER benefits on September 5th and is waiting to hear back.
Okay, so they're going to be entitled to that second week. I'll adjourn this then to September 19th, 2025 at 3 p.m. Young man, where are you from?
Northern Virginia.
Where?
Northern Virginia, right outside of Washington, D.C.
Okay, that's kind of my stopping grounds. I know where it is. I just didn't hear you.
Excuse me, Your Honor. Can I say one additional thing about this September 19th date?
Sure.
So I know that Mr. Stevens gets paid on the 22nd. Is it possible to do a 2-week adjournment so that he has a better understanding of where he stands?
I'm not sure how that has anything to do with the SER, Your Honor, but
it doesn't have anything to do with this year. I think he's looking to supplement payments, and so he just won't get his check until that Monday.
I guess I'm okay with the 26th. I'll be out of town, but that's okay.
September 26th.
Thank you, Your Honor.
2025 at 12 noon. Where'd you go to undergrad, young man?
I went to the University of Virginia.
UVA?
Yeah, UVA.
Maryland. We hate them.
I'm not so loyal.
Okay. What?
What a good one. What a good one. What a good one. But like I said, I created a new channel for the court stuff, and then YouTube, just being YouTube, wouldn't let me verify it. And I used my neighbor's phone to try to verify it with his number, and it wouldn't let me verify it. So I just deleted the new account. I'm going to leave everything on this channel. If people don't like it, tough titty. Because if you think about it, everybody, if I lose, if I move all the court stuff off of this channel to a new channel, I'm losing the views that I got on this channel. I've seen many, many channels deviate from their content and do other content. So I'm not the first person to do it. YouTube is just being YouTube. It wouldn't even let me verify my stupid account. I tried another number to verify it, and it said, oh, you've made too many attempts to verify it. Try back later. It's been, what, 3 or 4 days since I've created that account. I tried to verify it. So I'm just leaving everything on here. You know, it's just easier to do it from this channel and have to start another channel up and have to do it over again. So that's it for today. Tomorrow is Judge Flesher. I love Judge Flesher. I love Judge Flesher. He's a good judge. He tells it like it is. So you all have a wonderful evening. I will see you tomorrow at 3 o'clock with Judge Flesher. Ciao, ciao, ta-ta. And I will see you soon. Have a good evening, everybody.
solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. To all you do, from the highest peak, I can see it through. With your care and touch, everything's over.